Okay. So I'll just have a brief introduction. My name is Deanna. I'm the co-president of the Rutgers International Law Society, and we're very grateful to welcome everyone to this introduction to arbitration, and especially with a focus on investor-state arbitration today. We're very grateful to have our hosts with us and our moderator, Erica Levin, and I'll briefly give the mic to Josh.
Sure, yeah, just wanted to follow up, and as Deanna said, we're very happy to be hosting this event on behalf of the Cornell Law International Arbitration Society and NYU's International Law Society. So thank you all for coming. We're all very excited for tonight's discussion. And with that, I think we'll hand it over to Erica.
Thank you. Well, so welcome everyone to tonight's panel. And again, a special thank you to the Rutgers International Law Society, the Cornell Law International Arbitration Society, and the NYU International Law Society. My name is Erica Levin, and I will be moderating tonight's discussion. First things first, I have to say it's a pleasure to be here with you, although I wish we were in person. This is the next best thing, and we do what we can. I want to commend the organizations, and in particular, Deanna from Rutgers and Josh from Cornell, for their initiative in organizing tonight's event. And I'm especially grateful to our esteemed panel, who I will be introducing momentarily, for joining us. And last but not least, thank you to the audience. You're the reason why we're here, and our hope is really to give you an overview and an introduction into this topic. To the extent that we can be somewhat informal, we will. Please put your questions in the chat room, in the chat section, and we'll try to address them. And whatever we don't address during this event, because it is rather short, we can get in touch after. So very, very briefly, for those of you who don't know me, I am a practitioner and arbitrator, and I serve as an adjunct professor at Rutgers Law School, where I've worked for years and years. My specialty is international commercial arbitration. I'm now a partner at LBKM, which is a boutique law firm focused on international disputes. Without further ado, for this evening, we are joined by wonderful panelists. We are going to be covering a few different topics, three in particular: the impact of COVID-19 on international arbitration, the reforms of investor-state arbitration, and the similarities and differences between the future of investor-state and commercial arbitration. We could go on for a really long time with one of these topics, so forgive us, we're going to be kind of brief, but it at least will whet your appetite, and then we can always have further discussion. So I've kept you waiting. Tonight's panelists. First, we have Melida Hodgson, the head of Jenner & Block's New York International Arbitration Practice. Melida was recently elected as the vice chair of the ICC Institute of World Business Law, which we are all very proud of her for. She's a renowned practitioner, having represented Venezuela, Panama, Peru, and Sierra Leone, and amongst others, I'm sure, in both ICSID and UNCITRAL matters. She also worked for the Department of Justice and served as an associate general counsel at the Office of the United States Trade Representative, where she litigated trade disputes before the WTO and provided counsel on NAFTA arbitration. Next, we have Professor Susan Frank. I guess wave just so people know who you are. I'm sure they know you already as well. A renowned expert in international economic law, dispute settlement, and empirical analysis of international law. She's on the executive council of the Institute of Transnational Arbitration and is very widely published. Her last book was Arbitration Costs, Myths and Realities in Investment Treaty Arbitration. And I'm sure there's a lot of other publications that we're missing, but for now, we're trying to keep the introduction short. Our next panelist is Professor Kristen Boone, the Miriam T. Professor of Law at Seton Hall University. Professor Boone is a renowned expert on public international law and international arbitration. You're sensing a theme here. She also serves as the Associate Dean for Faculty Research and Development and has previously clerked for Justice Ian Binney of the Supreme Court of Canada. And last, but certainly not least, Eliana Barden, who practices with the law firm of Eversheds and Sutherland. She also is an international arbitration practitioner, and she's represented both sides of the aisle in several prominent ICSID arbitrations. She's the chair of the International Law Committee of the New York City Bar Association, and also teaches arbitration advocacy at the Brooklyn Law School. So without further ado, I want to thank our panelists and welcome everyone. Just as a very, very brief introduction, because it's hard to gauge the level of the knowledge in the room, and I do recognize that this is somewhat introductory. International arbitration is what we're focusing on today. For those that don't know, and I'm sure all of you do, international arbitration is an adjudication mechanism, a judicial dispute resolution that involves parties resolving their disputes via a tribunal of arbitrators based on a prearranged dispute mechanism embedded in a contract or an investment treaty. As a whole, international arbitration covers both international commercial arbitration and investor state arbitration. So, IA, if you're going into the world of international arbitration, get ready for alphabet soup. They love alphabet soup. Everything is different alphabet. So let's start. IA, international arbitration. There are two main subsets: international commercial arbitration, which is more of a private mechanism. It involves groups of private parties from different states who have agreed to submit their dispute to a panel of arbitrators. The panel will then conduct a hearing and they'll hear evidence and they'll produce an award, which is binding and enforceable in many countries, thanks to the New York Convention, which is very, very important to those of us that do international commercial arbitration. There are aspects to international commercial arbitration that are going to be distinguishable from the other subset. Investor state or investment treaty arbitration is a form of dispute resolution that shares some features with ICA. I wonder if anyone can guess what's different. Rather than arising from party agreement, like international commercial arbitration, investor state arbitration depends on the existence of an investment treaty. The investment treaty will outline the substantive protections that the investors are guaranteed when they make an investment in a host state. It's used to resolve disputes when there are allegations of improper government conduct. So think of some sort of a governmental restriction, some sort of a change that has occurred after a foreign investor has invested in another state. What do? They rely on the treaty that exists between their home country and the host state to commence an arbitration. One very noticeable distinction is that investor state arbitration, not only does it arise from an investment treaty, but it's public in nature. You're dealing with state entities. And for that reason, it tends to be very transparent, or at least that's the idea. I do not want to take any more time because we have really, really wonderful colleagues and a lot of really interesting topics to discuss. So I want to break in to our first topic. And for that topic, which we're going to be focusing on COVID and the impact of COVID in international arbitration, I want to pose a few questions to our panelists about what they're seeing and what their experience has been over the last few months. And for that, I guess first let's talk to Ileana. Can you give us sort of an impression of what you're seeing in your practice as a result of COVID?
Yes. Hello, everyone. Can you hear me? Okay, good. Thank you. Always have to make sure to unmute myself properly. So thank you very much for the invitation, and thank you for your question, Erica. I was, as I was thinking about this panel, I thought about last year, about this time, when I heard a lot of discussion about great disruptors of our time. We talked then about AI, artificial intelligence, shift in the economic power on the international plane, changing patterns of globalization and the like. But little did we know that come 2020, we will experience the greatest disruptor of our time, and that is COVID-19. I need not tell you that COVID has disrupted our lives on all levels. I probably need not tell you that it impacted our professional field, and I'm sure it has impacted your studies. But what we will discuss today is how COVID has impacted the practice of international arbitration and consider where do we go from here. To me, it is helpful to consider the impact of COVID on international arbitration from two perspectives, the substantive perspective and the procedural perspective. So let's talk about the substance or the substantive perspective first. We all know the great lengths to which national governments around the globe has had to go in their effort to contain the spread of the virus. States imposed travel restrictions and instituted lockdowns. They requisitioned equipment. They lifted mandatory payments that would otherwise be due to private businesses. Such policies impacted countless businesses and sometimes put in question their ability to survive the pandemic. So, going back to what Erica mentioned about the change that may have occurred after the investors made their investments, one might wonder whether these policies that were recently instituted by the government may and will give rise to new claims by foreign investors for violation of their investment treaty rights. One might also wonder whether these very policies may satisfy the requirements of state defenses against international liability, such that the states might actually explain that the policies were necessary and they were taken in order to defer a more significant peril. I would perhaps, before speaking more about sort of the specific angles, I just wanted to also ask Melida whether she in her practice has encountered a lot of COVID-related cases, or what is, Melida, your view generally about whether we will see a wave of COVID-related cases?
Thanks, Liana, and thank you to the organizers for inviting me to participate today. I'm going to take a step back and just say that I agree with Liana that we have to look at it in terms of procedural impact as well as substantive impact. The procedural impact, I think we've definitely all adapted, the lawyers, the arbitrators, to virtual hearings, essentially, just as you all have adapted to virtual classes. We have adapted to interviewing witnesses virtually, to having hearings, or at least certain kinds of hearings, procedural meetings with arbitrators virtually. I think that there's some issues there in terms of how it impacts different kinds of parties, particularly state parties that may not have as sophisticated IT capabilities as those of us sitting in law firms, for example, or large universities that have great power to negotiate with, or at least I'm not sure anybody had power to negotiate when we went into the pandemic, but at least now with many different vehicles available, there's some issues that affect sort of the procedural aspects. But in terms of substantive aspects, and in answer to Liana's question, I've not seen yet a deluge of claims. And certainly there was a prediction from various sources that there would be a deluge of claims, particularly on the international, in the investment arbitration side of things. I think there can be several reasons for that. One is it actually, I think, takes time to decide that you've got a claim that you want to spend money on lawyers to bring. You may be waiting, various entities have been waiting to see how long this would be, and to sort of figure out, are you actually damaged enough to decide to pursue a claim against a state. Obviously, just as with normal business relationships, once you take something to a formal adversarial proceeding, it could impact your relationship with that party, particularly constituents or citizens in a particular state who all feel like they're suffering also. So I think that's one reason we may not have seen it. There are considerations like that. There are considerations as to and you need time to actually figure, your lawyers who are not going to be able to visit witnesses in locations around the world need time to actually draft, A, figure out whether or not you have a claim, and B, then draft a request for arbitration. And most treaties will require you to go through a process of negotiation before you can actually bring the claim. So I think 8 months into it, it's probably a little bit too soon, but I also agree with Liana that there are different kinds of considerations. Also, this is not your normal claim of discrimination that you might bring. you need to consider how successful, what's the likelihood of success that you're going to have, saying that a measure taken to protect lives, was that there was something better they could have done. I mean, it's, arbitrators have to put themselves in the shoe of basically judging actions that are taken by policymakers, and that's always rife with problems or concerns, but particularly I think in this kind of a context, who's to say that they could have done it or there was a better way to do it? And so I think those are the kinds of concerns that we would have, and if you're thinking about bringing a claim and going to spend money on it. And so I think that probably has had an impact. So I guess if I would summarize, I would say it's probably too soon. And I think the claimants have to be very careful about the kinds of claims they would bring, both because of the likelihood of success and the potential impact on their business, just in terms of goodwill in that sense, not the traditional meaning of goodwill, but sort of how they're perceived.
Erica, do you mind if I just jump in with kind of a question? I was listening to Uliana and Melida, and it struck me that I was reminded of the Greek financial crisis, and how when that happened, people were terribly worried, especially in terms of what it would do to the Eurozone and its economic viability. And despite the kind of the predictions of gloom and doom, I don't think that there were actually that many claims substantively, right? So maybe this is just part of the adage of when bad things happen, people need lawyers, and they have to figure out how to do their risk management when they're trying to do the best they can in a very difficult situation. And maybe that's part of the substantive explanation, is that it's just the latest phenomenon of the kind of the normal human byproduct of what I think Uliana quite rightly called the great disruptor of our lives.
No, I think that's entirely correct. And I think, just as in any sort of interaction, whether it's investor state or in international commercial arbitration or any dispute, there's an emphasis right now on negotiation, interaction, communication with the other side and with the adverse parties. And I think it really does depend on the nature of the issue too, right? Is there an outright expropriation? Is there an outright negative impact? Is there something that can be ameliorated? And I think the impact of COVID is quite unique from prior analogs in that it continues. And so I think people are waiting to see, well, where's the end and what's the damage? And then do I assess and bring this claim or not? Or, so there are aspects. And then the other thing I do think, in terms of Melida's point, too soon, there are a tremendous number of temporary stopgap measures that are in place in various jurisdictions. So even if you wanted to, good luck, right? So I think there are other aspects. I don't know if anyone else has any comments on this topic. Uliana, do you have any other thoughts?
No, I cannot agree more. I think it is just too early to know for sure how necessary some of the steps that the governments were taking really were. And as Melida said, whether there was a better way. Unfortunately, we probably will not know for sure until we reach the other side, and we are not there just yet.
Yeah, and if I could add one more thing to that, it's possible that a lot of investors will have benefited from any measures that were taken to protect economic measures that were taken to ameliorate, I shouldn't say protect, ameliorate the effects of the measures that have been taken. So, contrast with the 2008 financial crisis, where, thinking of Susan's example, there were all these fears that Canadian investors, for example, who were not part of TARP, and for those of you who are too young to know about TARP, that was the measures taken to protect after the crash of Lehman Brothers and other big financial institutions, the effect that had on certain economies, namely in this area. There were big concerns that Canadian investors who had not similarly benefited would bring claims against the United States. To my memory, there was not one notice of dispute, even not setting aside the possibility of a notice of arbitration or request for arbitration. I don't even think there were notices of dispute. So, you know, in some ways they may have benefited, or in some ways they may just have decided it wasn't worth moving forward on something like that.
Could I ask the council who's actively involved in this a procedural question? Would that be okay? I'm sorry, I'm a little bit proactive today, but my students who are here know that I love substance procedure distinctions. And so this is just way too ripe. I just did Erie. I have to actually bring this up. But I'm curious in terms of process related issues. International arbitration is renowned for its effort to be fair in terms of procedure and comply with due process in the sense of giving everybody a chance to have their day in court. And I'm wondering how in an era of technology and using all the mediums that both Uliana and Melida were talking about at the beginning, how is this changing the nature of due process, or indeed how you're staffing your legal teams internally?
That's an excellent question. Melida or Uliana, I don't know who wants to take the first stab.
Impacts how we're staffing, or I mean, it doesn't necessarily impact how we're staffing. Everybody is virtual, so we really as firms have moved along just as if nothing has happened almost. Obviously, we all feel the impact. I think that there is an impact, however, on clients that maybe those of us who are lawyers who are moving along just fine. We have incredible, huge IT departments that, you know, just turned on just flipped in you know, an instance and days and created this whole universe that probably they've been preparing for years for various reasons. But we're all, you know, the kids are all right in that sense. Problem is that a lot of the clients aren't. And, you know, a lot of them have been in lockdowns that would have, in this country, caused a revolution, never mind insurgencies. You know, they've not been able to go to work. Some of them can go to work some days, some can go to work other days. I think for them, the impact has been much more severe. And then you add to that the capabilities of the technological capabilities, Wi-Fi, reliability of Wi-Fi. And then you add to that time zone issues, which I think, you know, we're dealing with international arbitration. We're not dealing with arbitration across this continent. And that has a huge impact because I know that there had to be considerations given to, if you've got someone, for example, the extreme would be Singapore, right? When do you schedule? Do you have them start at 11 p.m. Or, you know, 10 p.m.? And who's gonna, no one's really gonna start at 3 a.m. I assume, although you may have to get up at 3 a.m. to get ready to do something at 6 a.m. And so those kinds of consideration, I think, you know, are very much a part of the discussions.
Yeah, I think the due process question is one that is especially important just because, you know, we're seeing debates as to, well, when you don't have both parties agreeing to go forward virtually, what happens? Will that constitute a due process violation such that we cannot enforce the award later? And in an ideal world where everyone is forthright and honest and has good faith and only says that they can't proceed virtually when they can't, that's okay, that's fine. But there are instances where that may not be the case. And how do arbitrators deal with that? And how do, you know, parties deal with that? Counsel? I wonder if Uliana has any thoughts or any experiences with respect to this aspect.
Thank you, Erica. Excellent question again. And I, again, would like to sort of look at it from two different perspectives. I think there's a difference from you know, in all of the aspects of arbitration that involve the tribunals and that do not. So essentially everything that involves us as counsel, when we have to perform our duties, whether it's, you know, preparing written submissions, whether it's being involved in disclosure or in inter partes discussion, that is kind of proceeding virtually, but all of the challenges that sort of are implicated in this process are really logistical challenges, not so much legal challenges. But when it comes to the question that you just posed, Erica, and that's, appearance before the tribunal, and what do we do when the parties essentially are in disagreement as to, we are in a pandemic, we cannot have a hearing. Do we risk in person? Do we reschedule our hearing, or do we do it virtually? The situation is rather simple when the parties are in agreement, but when they are not, that becomes a little trickier. So one thing normally that we would do is just to look at the arbitral rules and and the lex arbitrii to even figure out if the tribunal has the authority to require virtual hearing, because there is some split of authority between practitioners as to whether there is or is not, whether the tribunal has that implicit authority. Again, if either of these sources tell us which way it is, then it's kind of easy. So what do we do when they don't? And typically they don't. My personal view is that the tribunal should be considered to have the authority to require the parties to proceed to the hearing under their case management responsibility. I would not extend this authority to any situation when a party just on its whim decides to not have an in-person hearing, but we are right now in an upside down world. So that is different. That is very different than a party just it says it's not convenient for me to appear and hence I will not. And I think that in this world, when in this time when the world is suffering from COVID, I think the tribunals may and actually must be in a position to progress the cases with the tools that are available to them. Now, the question between sort of having an in-person hearing and having a virtual hearing is quite often by people who oppose a virtual hearing is being presented as, you choose between the two, but that's really a false narrative, because the real question is, do you have a hearing now and progress the case, or do you delay it for an indefinite future? But even putting this sort of consideration aside, I actually think that international arbitration, as a community, we may be graduating towards something that we may become more comfortable with the technology and with virtual hearings. I personally do not believe that virtual cross-examination necessarily suffers from certain flaws. I actually think it's more about just having enough experience to figure out what needs to be placed when and how to organize everything, rather than just being having an inherent lack of process that is required to provide, the party's ability to represent itself adequately. But I do understand that there is some benefit to doing things in person, but it's just not available right now. One thing I will mention, and that goes to Melida's point about time zones, that is certainly a challenge. We actually are gearing up for a hearing where we will be beginning our days at 2 a.m. and going until 8:30 a.m. Because of who is on the tribunal and who is on the other side and where they are located geographically. However, I still believe that sort of between our team being inconvenienced for that 7-day period and our client not being able to receive reparation for the years to come, that's really the consideration. And ultimately, we have to serve our clients.
Thank you, Ileana. I think you've set the questions in a way that really makes us think, right? And it's always about framing and how you frame the question. And so I thank you for that, because I do think the rule of law is at stake, right? And you don't want an abuse of the process, and you want to make sure that people have their day before the tribunal, and we can accommodate when we can. And I do think there are aspects where the accommodation is necessary and the delay will be necessary if the infrastructure is not there. And it's a case-by-case situation. And I think it will depend heavily on who your tribunal is and the tribunal has to take those measures, whether it be checklists, they have to be proactive, and they have to understand what their rights are, their powers, excuse me. So I want, if you'll allow me, to transition slightly. There have been a number of discussions over the last few years in terms of the investor state model. And one of the benefits of being public and transparent, so to speak, is that encourages discussion and challenge and criticism. And over the last few years, there've been a number of discussions on this topic. And more recently, the Untitled Working Group 3 has been taking its initiative and addressing the reforms. And I was hoping that Kristen, and to the extent anybody else, Susan or anyone else on the panel would like to comment, if you could just, first off, Kristen, if you could give us an insight into what the reforms are that people are discussing, what's the current debate, just kind of give us some insight from your perspective.
Sure. Well, thank you very much, Erica. It's great to be here. So maybe I'll start with why there's a perceived need for reform. And I think really one of the crucial issues is that, there was a baseline assumption when bilateral investment treaties and multilateral instruments that provide for some form of investment dispute resolution were set up, that it's important for attracting and retaining foreign investment to have these independent mechanisms. And there's been a lot of empirical work done that really pushes back on those assumptions. And so some of the concerns with the system, I think, have emanated from this idea that this kind of supranational, independent, ad hoc investment system is actually, relevant to attracting FDI for states. And then there have been a number of other things that have happened, which have led states, I think, primarily to have cold feet about whether or not to continue with the system. And so there have been a number of big cases that have been brought against states that have involved really sensitive issues of public policy, health issues, questions of fracking, questions about tobacco regulation. And when investors win in those circumstances, the awards, of course, are paid by the public purse. And there's been a perception that this, invitation to this unilateral right to sue on behalf of investors actually has not been good for many states. And so over the last 5 years, there's been a lot of countries who have deliberately and very, with lots of publicity decided to exit. And they're pulling out of the treaties that they had originally signed on for. And, some of the prominent countries are like Venezuela and South Africa and Brazil. So, the concern has really been, regulatory chill, that states don't want to do things that actually might be in the best interest of their public because they're afraid they're going to get sued. And this concern about bias and this underlying assumption that maybe, in fact, investment arbitration is not necessary to attract arbitration. So that's sort of the framework. There's a big set of issues that are kind of going on right now that involve how to reform the system. A lot of it is sort of promulgated by states directly. And then there's some stuff going on in the margins that are more about, indigenous peoples or corporations and how they're getting involved in the conversation. But because the system is based on treaties, it really has been states that have, on the one hand, tried to come up with new treaties that have provisions that are more beneficial for them. And so some of the treaty provisions themselves are changing in the new generation of treaties. And on the other hand, there's this whole system that you mentioned, Erica, the UNCITRAL 3 working group that's going on right now. So that's a group of the UN Commission on International Trade Law. And they started in 2017 having meetings, 3 or 4 a year, where they bring in international delegations to discuss, what the problems are from the system and what the reforms might be. And for students, this actually might be a really interesting thing to keep tabs on because they just held their last meeting just last week, or 2 weeks ago, really, in early October. The next one is going to be in April. Normally, they take place in either New York or Vienna, but because of COVID right now, to go back to our COVID discussion, in fact, it's happening virtually, right? So there's actually a great opportunity to, kind of get on to some sort of national delegation or team up with, an NGO or some organization that's involved in this and be part of the discussions, because I think it really is charting the future. So I can talk a little bit about some of the specific things that are on the table, Erica, or we can open it up. I don't know what you'd like to do.
I think that would be great, just some of the specific ideas, if you don't mind,
Sure.
just to give us an idea as to the discussions that have recently taken place.
Yeah, okay, I'll just mention a couple of them, and all the other panelists have, lots of deep knowledge in this area too. So I'll start, and then, please everybody else chime in who would like to. So one of the big discussions that's happening right now is whether or not the current system of ad hoc investment arbitration should be replaced by a court, by a standing permanent court. And also whether there should be an appellate mechanism that's added on to that. So right now, there's a lot of, things can happen under different treaties and in different locations. There's a real concern about consistency and predictability. And so, part of the thinking is that the process of dispute resolution needs to change by setting up, a court that would look a little bit like what's happened in the WTO, the World Trade Organization system. And so that proposal, to have something stable, institutional, with a sitting body of arbitrators is fairly far along, and it's got a fair amount of support. I mean, I don't think the U.S. would be joining a permanent investment court anytime soon, but I think a lot of other countries think that there's benefits to it, and so that's one of the big conversations that are happening. Corporations have been somewhat critical of this because they are concerned that it would be too pro-state. I mean, what the investors want is a neutral system where they can choose their own arbitrator, and then the state chooses one, and then they choose a neutral third. That's usually how it works. And so there have been some, some like corporate groups are going on record saying that we don't know if our interests are going to be adequately represented if it's the states that control the process about who the arbitrators are. Another thing that's happening is that a code of conduct for arbitrators is pretty far along in terms of its discussion, and one of the things that's being focused on there, other than the usual rules of professional ethics that you would expect to see, is what's called double hatting, and that involves situations where somebody is both in private practice and also acting as an arbitrator because there's concerns about conflict of interest. There's also a variety of other, topics that have risen to the forefront. There's such a thing called third-party funding, where there were corporations that were actually looking for claims that they could invest in, and then if they kind of like was like a class action, and where they would invest in the claim, and then they would kind of get some of the proceeds afterwards, and it enabled the investors who wouldn't normally have the funds to launch a big case to get the financial backing in order to proceed. But that has been, that has raised a lot of concern because the people paying for the claims to be brought don't necessarily have a direct interest in it. And then it's the states that end up paying if they lose. So there's been focus on how to reform that and limit that. And then I think that there's a few other things that have come up, with regards to trying to right the balance for states, right? So to kind of think about counterclaims, like how states, and this is really a treaty law issue, not a process one, but what treaties and under what circumstances could a state bring a claim against an investor? So, you might have an investor that sues a state for some sort of regulatory taking, and then the state could come back and say, but you were violating the right to health, or you polluted the environment, or something like that. So that kind of gives states a little bit more say in what's going on, and enables them to show a different side of the story. And with that, I think there's also an emphasis right now on alternative forms of dispute resolution, like an ombudsperson, and things that you can do sort of earlier on to stop, the full-blown claims from coming up. One thing that I looked at and wrote an article on was small claims, saying that, it would be good to have actually a small claims mechanism, which is quite normal in commercial arbitration, because there's a lot of investors with small claims, or big investors with small claims, that are kind of shut out of the system right now, because usually the claims that are brought against states are quite large. So that's my 2 cents on that. But Susan, Melida, Leanne, anybody else who wants to chime in, please go ahead.
I mean, honestly, I could talk about this until the cows come home. I mean, this is one of those issues that it's a perennial chestnut. Should you be reforming? Should you not? I mean, my very first law review article that came out in the Fordham Law Review in 2005 really was about what's going on with consistency, transparency, reform of structural bodies. Let's not forget, in 2010, I believe it was, Melida, correct me if I'm wrong, but the State Department and USTR got together and created a model investment treaty that set a framework that would permit a conversation about the creation of appellate bodies. That was about as loose as it went. It didn't say we will create some kind of an appellate body, but they structurally put text into the model treaty that said at some point we could consider having some sort of appellate reform possible. So it's not as if these issues haven't been on the table for a while, but there is this really interesting blend where people, in my view, are thinking perhaps a bit more about procedure rather than substance, when it may indeed be better to focus on it the other way around. As Professor Boone was indicating, this is largely a matter of treaty law when you're in the treaty arbitration context, because there are substantive provisions that states have agreed to within the text of those treaties. So to the extent that states wish to change or shift the rights that they grant to foreign investors, they are perfectly entitled to do so. To the extent that states wish to create express defenses for themselves within a treaty and not have to rely on other issues about, is there a public international law defense of necessity, and what are the contours of that, and how should it apply in this case? States hold the pen, which means they can decide to change the rights and defenses that are available as a matter of substance in the investment treaties. But I sometimes wonder if people put the cart before the horse and focus more on the dispute resolution mechanism rather than the importance of the substance that sovereigns agree to trade away when they trade in a treaty in hopes of securing foreign investment. But I'm sure that raises all sorts of concerns and ideas from my fellow panelists, so I'll leave it for the moment.
So if I want to add just a context to this, because I think it's something that gets lost and is really important. The working group 3 negotiations are really a product of a process that happened, a political process that happened in the EU after the Germans got sued for the first time. Now, context to that is the Germans were the ones who actually created the bilateral investment treaty model that most of the world uses, which is very, very pro-investor. Let's go back to answer Susan's question to 2004, 2005, after, every president, starting with Bill Clinton, and Democrats paid for this in the last round of elections, has sort of promised to either not do NAFTA or revisit. Bill Clinton promised not to do NAFTA. He looked at it, said, actually, this isn't so bad, we're going to do it. And Democrats paid for that in 2016 because of the effects of it. Whether or not it affected in terms of investor-state arbitration doesn't matter. That's the public's perception. And so within the 10 years after the United States got sued, because no one expected that the United States would get sued, but Canada's has been, I think it still is, the largest investor in the United States. And so Canadian investors sued the United States for things like environmental policies, judicial decisions. These are holy grails in the United States. And so we went through a process, and I was part of this process of in 2004, actually, of saying, no, we need to change these treaties. We need to change NAFTA. And we did that, and we put in a lot of provisions, transparency provisions, into the procedural aspects of the treaties in order, and also substantively to the substantive protections to limit the scope of arbitrators to interpret what the provisions meant. As Susan says, the states are the owners of these documents, which are a waiver of sovereign immunity. So they have a right to put it whatever way they want to. So that process happened in the United States, like in 2005. I think it's interesting that the United States is now viewed as sort of the outsider not wanting to realize and do reforms. Well, the reality is that the US went through that process and did the reforms that it needed to do. So why should it be part of this process and go along with everything? I think states are free to come to the United States and say, we want to change that treaty. And frankly, I don't know why, if Belize wanted, I have no idea if there's a treaty with Belize, wanted to change a circa 2000, 1980s, 1990s treaty. When the United States has this model, there's no reason why you couldn't change that. And so I think it's interesting that the US is sort of viewed as not wanting to go along with this process, which is really the result of an internal EU political discussion. And then you have all the countries that have actually paid for investor-state arbitration, Latin American countries in particular, that do want to see change because they have experienced it. But I think you can never get away from the political context. And in 2004, whatever it was, a Democratic Congress said to the then president, if you want these FTAs, then you're going to put something in that allows appeal. I mean, the resolution was that basically you would negotiate as to whether or not to have an appellate mechanism. I will tell you that the deep state did not really want that. And so it never happened. And now you pay the price in some way.
Well, it's quite interesting to have this historical perspective, because I do quite vividly recall in 2005, when I was making some of my initial presentations and pushing for the idea of structural reform in the form of an appellate mechanism, because it seemed quite odd to me that we would have international sovereignty on the line with no capacity to have a check on the legal accuracy of it. But I do recall several government officials telling me from European Union countries that perhaps I was wrong to have such thoughts. And I think that that's
now
about
they've changed their mind. So, and maybe they're not around anymore, and you have a different group of officials who have a different view. And so, you know, it's unfortunate. But, you know, on the substance question, one reason I think no one wants to go there is there were negotiations in the early 90s, maybe starting even earlier, on something called a multilateral agreement on investment to address substantive issues, and no agreement could be reached. And there were a lot of scarred people walking around the State Department and the Office of the U.S. Trade Representative and the Treasury Department, because why? Ultimately could not agree with the EU on the scope of the FET provision, which now in CETA and in others looks a lot like what the US thought it should look like. So there you go.
It's all fascinating, and I especially appreciate the framing and the historical context, and it will continue to evolve. And I think as we look to the future, this is something that we do have to dissect and to think about. And I think the substantive aspects are really important. I know from my background, I also had done work in litigation finance. And so I was very, very sensitive to the states and the concerns of the states. And it highlighted, this is something that Professor Boone was addressing, it highlighted sometimes the inequalities, or at least perceived inequalities in the system. And so I think there's an aspect where you have to be careful in terms of the substance, make sure that the process is working. And if the overall objective was to, you know, increase FDI, foreign direct investment, at what cost? And make sure that the states are protected and that it is working in the way that it should. In the same vein, investors are investing a lot of money and they need to be protected. And sometimes things are done that are not done properly. And so, you know, these mechanisms are in place ultimately to promote business, to promote advancement. And so, you know, these are not easy questions. And I think the problem is when things get politicized and we don't focus on the substance, it becomes problematic. And hopefully we'll continue to see things evolve. One question I guess I would pose, just as we're running a little bit short on time, is what do you see in terms of the future for investor-state arbitration with respect to international commercial arbitration? Do you see overlaps between the two? Just as kind of a final closing comment or thought, to the extent any of the panelists have something they'd like to contribute, I defer the floor to you.
Well, I'm happy to kind of chime in. My own thought is I think that it may be a demarcation between investment treaty arbitration and international commercial arbitration. And part of that is because of the substance that is involved. To the extent that you're arbitrating the substance of public international law rights, I think that that has a very different flavor. And I think everything Professor Boone said is profoundly important. I think to the extent, however, that you're talking about a joint venture agreement or the invoices that might be getting negotiated or litigated in, arbitrated in the international commercial context, I think that that's likely to be a little bit different. The commercial arbitration has been around for hundreds of years, going back to the Greeks and the Romans. So I anticipate that has kind of a healthy future just because of the nature of private to private dispute settlement, and we already have national law articulated by courts and legislatures to help us understand the meaning of the substantive rights granted in private commercial agreements. Whereas the meaning of public international law that is handled in a private matter and potentially inconsistent, in my view, is likely to have some slightly different trajectories. But perhaps Melida might beg to differ, as she has a bit of unique experience in representing certain clients.
So I actually think there is more of an overlap, and what we're seeing in investment arbitration will affect commercial arbitration. And part of the reason for that is we see changes already, for example, at the ICC, International Chamber of Commerce, where you see more transparency, where they're publishing who arbitrators are and are now putting in provisions. I think there are new rules coming into effect in January, whereby after 2 years or some time frame similar to that, awards, unless the party objects, I guess, awards will be published as opposed to just sort of summarizing results of different kinds of decisions. So, I do think that it's already affected the world. And I also don't think investment arbitration is actually going to go away. You have thousands of treaties out there that no one has bothered, including the countries that have been very much affected by investment arbitration. They've not sought to, get them annulled or changed or denounce them, and I guess it's a proper term. You have 1 or 2 countries that did that, and of course, maybe one thing those countries have learned is they actually continue because they have provisions that allow them to continue on for years, or allow investment arbitration to continue for years, even if the treaty has been terminated by one party according to whatever the requirements are. So I do think there's more overlap, and frankly, one interesting thing is that you have a lot of states, I shouldn't say a lot of states, a number of states that are using commercial rules, or putting commercial rules in contracts as a state that basically allow arbitrations that ultimately affect state funds. They may not be treaty per se, but if they lose, it's going to affect state funds. And so eventually someone's going to catch up to that and start to require then that there be greater transparency, or some provisions that allow for the fact that a state is not run the way a corporation is run. And so I do think you'll see maybe things like timeframes, where you just need to take into account that, a state-owned entity with 3 government officials that have to approve something can't make a decision the same way a corporation does. So I do think you'll see that.
And I think I just want to reiterate this point, especially because Professor Boone brought up third-party funding. The costs of these cases for the students in the Zoom room are not insubstantial. My own research, which is historically dated at this point, I'm not going to lie, suggests that on average parties are paying between $3 and $6 million per side. So on one hand, that's great for lawyers in the sense that there's potentially a revenue stream for your future. But on the other hand, that is an awful lot of money, both for investors and for states, particularly developing states. So to the extent that the investors might be able to benefit from third-party funding, but it's really challenging to get third-party funding for states because there's no upside to the financiers. And my understanding is the only financiers that have actually funded states have been in connection with some of those Philip Morris cases related to cigarette regulation. And then it was actually kind of like a GoFundMe public outcry where people decided to personally fund the defense of the governments that were trying to improve the health and welfare of their citizens. But where's the financial upside for the states that are having to pay for this massive bill internally, and they don't even know ex ante whether or not they'll ever get their costs shifted so that they can recover?
So I think that that's a really important point. And again, having been on the front lines in the third-party funding world, I will say, for the students, check out ICA. We did a huge study I co-wrote an introductory chapter, chapter 2, which will give you an overview of third-party funding if you're interested, especially in the international arbitration context. With respect to the states, it is a difficult proposition. There are funders who are trying to fund and to assist the states, but it's tricky. Why? Because the whole model of third-party funding requires a payout. It requires a recovery. The $3 to $6 million that Susan is talking about is on point, but you need a multiple, a big multiple to make that make sense. So think about that. So unless that recovery, potential recovery, or the damages are in the scope of 25 million plus, you're not bringing that suit, right? So from the investor standpoint, I will say this though, to defend impartially, but still to defend the funding world. They are investors. They do not make unwise decisions usually. And so those cases that are brought are vetted extremely, extremely carefully. So they're usually very, very strong cases. And what we do generally see, maybe not as much in the investor state world, or what we have seen is an encouragement for settlement negotiations and the like. But it is really an issue that is continuing to evolve and to be addressed and studied. And for those that are in law school, I encourage you to look into these topics and these issues. And one of the advantages, I think, COVID has upset the world in ways that we still are not able to understand. But through the virtual process, you can access a lot of people that you might not have accessed otherwise. And so I encourage you to do your research, to reach out to people. I think these are topics that if you need help, we can connect you to the right people. The key for me when Deanna and Josh approached me, and why I reached out to my other friends and colleagues, was to make sure that you have exposure to us, to our colleagues, to this area of law, because I think it's really important. And without the exposure, you don't know, and you won't be able to continue to learn. And whether you never practice in international arbitration or you do, it's important for you to understand what it is and why it is. And so that I really want to take a time just to say thank you to all of you. I know that this is, a night out from your work, and we can't even promise any sort of refreshment, so I apologize. But I will say, when COVID is all over, and it will be one day, I owe you some refreshments, and feel free to come visit anytime in the Chrysler Building or wherever in New York. But I do thank everyone for their time today.
Thank you everyone. Thank you to our panelists and to Eric, our moderator. I've posted the link to the Rutgers International Law Society YouTube channel. So if you want to keep up to date, we'll have the video posted of this panel as soon as possible. And with that, hopefully, I guess we'll turn to our questions, Q&A part. If any member of the audience has a question, you're welcome to speak up. You can raise your hand or just unmute yourself.
I guess I had an initial question for the panel, and thank you all so much. That was really a really fascinating discussion to get to listen to. We're all extremely grateful. I can't remember precisely whether it's Professor Boone or Melida who mentioned it, but it was mentioned that the kind of empirical research on whether kind of investment treaties actually facilitate greater investment in a country. It was mentioned that there was empirical research demonstrating that that presumption was not actually true. I was wondering if someone could perhaps speak to that a little bit more.
I think that was Kristen that mentioned.
Yeah, I believe it was Professor.
I have my views on that. Kristen.
Yeah, well, I mean, I'm just, I would actually be interested to hear what your reaction to that is, to Melida, because I think that there have been people who have done work. There's, book chapters and articles that have been written on this topic. And I think, Susan, you've also published in this area as well, too. And then there's, people that dispute that, but I think at best, there is some question as to whether or not, despite the proliferation of bilateral investment treaties and other mechanisms, it actually has, increased foreign investment. So who wants to respond to that? Because it sounds like
I'll give my view, which is that there is no proof that that's actually the case. Undoubtedly, in certain kinds of countries, it helps, undoubtedly. But you have to look at it also from both sides. First of all, is an investor really going in thinking, I'm going to do this because I'll be able to sue them if this doesn't work out? I don't think so. I mean, no one wants to go through that. Why? It doesn't seem like a good business idea to go into something. Is it nice to have? Is it part of a checklist of things that you maybe look at? Probably. But also from personal experience, I know that a lot of these treaties came into being because someone was visiting the United States, or the US president or secretary of state was visiting a country, and they wanted to have what is called a deliverable. And one of those deliverables is something like a trade and investment framework agreement, where you agree to set up an organization to talk to each other about having closer trade and investment relationships. The next step from that is an investment treaty. And oftentimes you do that for countries from the United States perspective that have been very good friends to you from a national security standpoint, not necessarily from an economic standpoint. And so it's not necessarily that that's the reason you have those things. And so that's why I don't think that's what investors are really looking for. It's one of the explanations, and maybe the World Bank has views on that. I think they're probably one of the ones that would say that, but I don't think that's the way it always happens. And I also think that if you look at ultimately certain countries like Brazil, which doesn't have any, negotiated them and the Congress refused to approve them. It's been doing quite well without bilateral investment treaties. So.
Yeah, I would agree in terms of the Brazil experience. I practice a tremendous amount with respect to Brazil, and while it does not seem to have had an impact on investment, but we have probably a very, very, very vibrant international commercial arbitration practice for a reason, because that works. The courts weren't necessarily working as well. And so I think you need some sort of mechanism, but whether there's a direct correlation between the FDI and the ISDS, it remains to be seen. But Brazil is an example of one that has not needed it.
I'm going to put on my empirical hat and encourage people to read the research and look at the methodology underlying the assumptions. What you will find, in my view, is some of the best research is coming out by people like Clint Pinehart and Todd Alley, also Susan Rose Ackerman and Jennifer Tobin. Also, Jason Yackey has some very interesting empirical work in this area. And you will find that more often than not, the issue of decisions to invest abroad are multivariate. And an example for one country may not be applicable to another. And as I'm being recorded, that is all I will say on that topic.
Any other questions? I don't want to keep people too much past our time. I'm conscious that we're a little over time.
If we don't have any questions, do the panelists have any other closing remarks they'd like to say?
I just wonder if any of the students have questions. You've got some amazing practicing lawyers here. I mean, why wouldn't there be questions about career paths and the future of your professional lives and how they may or may not track that of other people? So I want to just throw that out there.
I have a question. How did you all get into this area of practice? There aren't normally a whole bunch of law classes offered for this kind of thing that I've seen. So what was your trajectories, or what were your trajectories to get into this kind of thing? And what do you like most about it?
So I'll be very brief and say that I started off in a world where there were very few, if any, arbitration departments in a law firm. When I started out, it was sort of almost a province of boutique French firms at that time. This is almost 30 years ago. I would say over the course of the last 15 years, of course, it's become sort of de rigueur for every firm to have an international arbitration practice, commercial and or investment arbitration. So I started off in a general commercial litigation department, had an arbitration, a commercial arbitration, and really enjoyed it because I did not like motion practice. And I liked the idea that you could have a couple of briefs that you just sort of got to the point. You had 2 rounds of briefs, you had a hearing, and then the arbitrator decided, as opposed to years and years of litigation. Having said that, there are a lot of arbitrations, commercial and investment, that last years and years and years. So things have changed a little bit since then, but really for me, the investment arbitration part came from my experience in the government.
Now, I'll add in. So I worked at Debevoise before I became a law professor, and I think a lot of the big firms, the big commercial litigation practices, have people that do general commercial arbitration, and then they have people, or pardon me, they do general litigation, and then there's there's an element of that that's also commercial or investor state arbitration, and the workflow in the international sphere is not as great, right? So there was always a lot of competition to get onto the cases that were interesting, and Debevoise was a firm that had a big commitment to doing international law, both on the public side, because they had a really good pro bono practice, and still do really, as well as on the investor state side. But what I witnessed was just people being really good litigators, and then these things would kind of fall in their lap, and then they sort of started going in that direction. So there were some people who were quite directed about it when they graduated from law school, but a lot of the more senior partners in the firm at that time had sort of evolved into that area because I thought the issues were very interesting and they liked the party. So it's exciting, but I think that the people who succeed are just, they're good lawyers, and then this is part of their practice, and then some of them really specialize as time goes on.
And I will just add very briefly, because I realize that we are over time. So my trajectory was actually very indirect, and early on in my career, I tried both international tax and corporate law. I really liked international tax. I didn't like corporate law, so I did not mind it. But when I first was exposed to dispute resolution, I realized that's really what I want to do. And I would encourage all of you guys to really kind of try and search what it is that clicks with you, because there is no practice that is right or wrong, but there's a practice that's right and wrong for our individual personalities. What I like about dispute resolution, I just love the creativity and that sort of is involved in the process, and how you come up with arguments and strategize and all of that. And I found, even though I'm sure that corporate law is probably exciting to many people, to me it was just kind of a little plain. So it's really, really important, given how much time we spend working, it is very important to find that something that will keep you interested and keep you wanting to do more and more on a daily basis.
I have to concur with that 100%. I mean, my thing is follow your curiosity. Do what makes you happy and that makes you curious. And I actually went to law school not to do international anything. I went to law school to actually sue police departments in connection with failing to honor battered women's protective orders. But somewhere along the line, Lonnie Gunier caught me. She wrote an article that was called Becoming Gentlemen, that was all about how women enter law school wanting to do public service and end up doing more commercial related work. And I was genuinely fascinated about how people make decisions and what's going on with dispute settlement. So I actually got into international arbitration because of my interest in alternative dispute resolution. And at the time, international arbitration seemed a bit of an alternative. But what I want to flag is that while I was going on this journey, I didn't have anything focusing me other than my own intellectual curiosity. And that lets me ask, I think, more interesting questions than the average bear, because my perspective on this, whether it's laced by empiricism or psychology or what have you, it just means that I'm able to do interesting things. And then sometimes you just let life find you. And I will not lie, I basically got to where I am in my life because I went to a cocktail party with a purple pen. And that purple pen was very similar to a purple pen held by someone else in the room, a gentleman by the name of Bill Sherman, who had been the head of FERC. And he said he was looking for a summer associate to help him serve as a clerk in connection with a case where he was an international arbitrator. And we just hit it off, and that was that. It was very much a function of what's going to make me curious and who do I like working with. I really encourage you all to think about what are the things that make you happy and who are the people that make you happy, because you can't go wrong making life decisions that increase your happiness.
And I guess last but not least, and part of why I'm here today and part of why you have our fellow panelists here today, is I think it's really important for you to have exposure and to have access. And when I was at Rutgers, I basically thought I was going to do foreign public service. I had worked at the US Embassy in Malta, loved everything international. I was doing something international and most likely public. And then I stumbled upon this program called the VIS International Commercial Arbitration Moot. And I found out that if I took a summer class, I could try out for it as a 2L. And that for me opened up the world of international commercial arbitration. So I was a 2L oralist, then a third year I was on the team and helped the team. And then I went on to teach and coach the team. And then I went on to teach international arbitration. And all the while I did disputes, international, domestic, and more. And I joined Clifford Chance eventually. And I think one aspect about the international arbitration sphere is it allows you to meet really interesting people. I enjoy the comparative aspect of the law, and it really does make the world feel smaller. Right now, unfortunately, we can't travel the way that we're used to, but the world still feels small because you name a country and we know someone there, and you know someone who you can call on. And if you don't know one, you know someone who can help you. And so the aspect here is take advantage as much as you can of being a student and having this access. I know sometimes probably right now it feels a little lonely, but we're all out here. We're happy to help you. And this is a very exciting world. And I want to just kind of echo, follow your heart and make sure it's something that you're interested and curious about, because you are going to be doing a lot of work over the years. And you want to surround yourself by something that's interesting and surround yourself with good people as well. And with that, I really wish you all the best of luck. Stay safe, stay healthy. Deanna and Josh know how to reach us if you have questions or need anything follow up. So I wish you all the best, and thank you again.
Great, thank you so much. I guess we'll wrap up this panel. Thank you again. We really appreciate, we're so grateful for our panelists, for your time, for your wonderful commentary on the future of the investor-state model and arbitration generally. And thank you to our moderator, Erica Levin. And thank you again to Cornell International Arbitration Law Society and NYU International Law Society. And thank you again to our audience as well.
Take care, everybody.
Bye.
Thank you.